Hi, everybody, and welcome to Raw Law. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome, everyone. So this one was not scheduled. I kind of decided to do a last-minute live. So because of that, maybe I'll start off by answering some questions on our channel to give people time to join. And then once we have a few people here, you could, feel free to ask your questions, use the chat, and I will, of course, read the questions in the live chat and answer them. Okay, but I'm going to go to the channel, to the our YouTube channel, and read some of the questions there. Here's a question from Arash. He asks, if you cannot show work payments on paper, can you still sue for future loss of income if you get disabled from an accident? So that's a good question. Basically, if you can't show lost wages on paper, meaning maybe you're being paid in cash, right? You can still sometimes claim lost wages. That'll depend on the state laws. Like I know in New York, sometimes people get paid in cash, but they're still working. And so even illegal immigrants who aren't supposed to be working, right, but they're getting paid, they could still claim lost wages. There was some case law on that. But in other states, it might be a little bit different. But what you want to be able to show in a case like that is future lost earning capacity. And lost earning capacity is like the capacity or the ability to make money, right? So you're so disabled, you got so hurt, now you don't have the capacity to make money. That's what you want to be able to show. But in order to, have that evidentiary proof, you probably will have to be able to show that you were making money before, so I guess it would depend on the specifics of that question. I'd have to read that. I'd have to speak to you because if you can show, like, you don't have to be working right before you got hurt, but in the last 10 years, did you have an income? There has to be some kind of, because essentially it's like a paycheck loss, but if you've never had a paycheck, it's going to be hard. So whether it's, on the books, off the books, but you have to be working and, you do have to show some kind of ability to work and capacity for employment. And then the fact that you can't work, because of the injury, now that's your loss of the future income ability. So I hope that helps. And I think there was another question from the oh, here's a question. Do you see many motorcycle involved cases? I was stopped at a red light on my bike in September of last year, and a woman rear-ended me 4 to 5 times, causing me to tip the bike and attempt to save it, causing a lot of soft tissue damage to my left shoulder, back and neck issues. Have received shots in my back, neck, shoulder from the doctor. No MRI, just x-rays. I had a good concussion and migraines for a while. Pain shot up and down my arm for weeks, working in a manual job, plumbing. I couldn't really afford to miss work. I have bills to pay after all. Couldn't perform my job to the best of my ability, of course. Nervous and stressed to get back on a bike again, dealing with progressive insurance. So what do you think my case would be worth? Thank you. Yeah, so I mean, the first thing I would recommend is definitely try to get an MRI, because if you don't have an MRI, it just means you don't know what the injury is, especially with your back, right? Because your back is obviously inside the body, the spine, the discs. X-rays are not going to show anything unless it's a broken vertebrae, a broken or a fractured spine, which is pretty rare. So if it's a disc injury, like a protrusion, herniation, bulging disc, protrusion, anything like that, that's going to be the disc and the nerves, which you cannot see on an x-ray. So you need the MRI to diagnose that. Then once you know what the injury is, now you're in a better position, right? Because now you can see a specialist. The specialist could say, you need pain management, you need injections, you need surgery, or maybe you don't, right? But you can't really even start the process if you don't even know what the injury is. And that's the medical diagnosis. That's step one. And once you have that, it could be worth a lot because look, you got rear-ended. It's not your fault. You can even make a summary judgment motion and get judgment as a matter of law. Then it all becomes about your damages. If you're missing time from work, you get lost wages. It sounds like you have serious pain and suffering. If there's a concussion, you can get checked out neurologically with a neurologist. That could be a head injury, which could even increase the value. So, I mean, I don't know where you are, but that could be a big case. That could be into the six figures easily, meaning hundreds of thousands. And if it's a true like traumatic brain injury, it could even be potentially into the millions. But, I would say something like that, just text me 347-566-9595. I'm happy to chat and discuss that and give you better advice. Okay, and let me see. We have some live questions. Here's one from Felipe. He asks, is it true I can do multiple IMEs if the defendant asks for it, or is it always one? Yeah, I mean, sometimes there are multiple. Usually they can't just ask for it for no reason, right? The reason they would be entitled to multiple IMEs is if you're claiming different injuries. For example, some of your injuries are orthopedic, right? And other injuries are neurological. So now they can claim an orthopedic doctor as one IME and a neurologist as another. For example, if you have a head injury, that's the neurologist, but you also have like a broken left foot, that's the orthopedic, right? Then they would get both. But if you don't have one, right? If you have a simple injury, like I just have a bulging disc and that's all I have, well, they can't start getting multiple ones, especially if you don't have multiple ones. Usually they try to mimic what you have. So if you have, let's say, a neurologist and an orthopedist, then they can get a neurologist and an orthopedist. Like that's usually how it works. And then Come Along with Uncle Joe says hello. Hi, how are you? And Leonardo says hello. How are you? And Hassan says, hi, Arkady. Does lost insurance coverage qualify as lost income and lost retirement contributions as well, since I got medically terminated from my job? So you lost your insurance coverage as well as your retirement contribution. You could add that. I mean, it would have to depend on the state laws. But yeah, I mean, if you lost the benefit because of your injury, you may be able to try to claim that as part of the economic damages because you have the lost wages, obviously, right? You're not able to work or you're terminated because of the medical injury. So now, of course, you lose other benefits of employment, such as insurance, such as retirement contributions. So I think you could try to add that in there. Okay, and then Willie says, good evening. How long can it take to get car damage fixed from the person that caused the accident? Is there a time frame? Thanks, Arkady. Yeah, I mean, usually car damage is pretty quick. If you have collision, usually your insurance just goes out and takes care of it and pays you. If you don't have collision, the defendant's insurance takes care of it. They're supposed to do it fairly quickly, like a week, 2 weeks, but sometimes if it's a bad insurance company, they just don't respond. So if the worst comes to worst and they're not taking care of the car damage, what you could do is when you sue for the bodily injury, you just add the car damage to the lawsuits. Now you're suing for both. Usually the statute of limitations on that would be the same as the personal injury. So you could just add that into the complaint. And then SCB says, New York City, Manhattan, premises liability case, TBI, fractured skull, T1 to T3 compression fractures, still in treatment, NOI just filed, what to expect next? Yeah, so that's a serious case. If you have a premises liability with a TBI and a fractured skull and compression fractures, and you're still in treatment, obviously it's a serious case. I don't know how the incident happened, right? What's the liability if you have an expert? But yeah, feel free to text me. I'm happy to do a free consultation. It's confidential, 347-566-9595. What I would look for is something like that is an expert, like maybe an engineering expert, because if you have really serious injuries, your damages are good. But remember, you don't get to even talk about damages unless you first prove liability. So I would like really strengthen the liability, get like experts, the building codes, whatever caused the fall, maybe engineering or safety experts. Now, once you have that, then once you file the note of issue, the case goes on the trial calendar. And if it's in Manhattan, it's actually a unified trial. So that's the first department. But you're going to have, before you get to the trial, what happens next, you're going to have like possible mediations, you'll have pre-trial conferences, settlement conferences. So you'll have activity, and then your lawyer should be reaching out to the other side if you want to try to settle the case. And RDOT says, if our injuries expenses exceed the defendant's policy limit and the defense lawyer doesn't want to tender the policy, can we now get or ask for more money at trial under bad faith? The policy is $150,000. Yeah, exactly. That's how bad faith works, right? So you give them the opportunity or the chance to resolve the case within their policy limits. Like you say, look, I have my medical bills are $200,000. My injuries are severe. I have fractures. I have surgeries. I'm going to need more treatment. I have lost wages, but all you have is $150. Just pay it. But if they say no, okay, now they've lost the chance. And now when you go to trial, you're not limited to the $150. Remember, insurance is one of these things in a jury trial for personal injury that you can't talk about, right? Great. So I'm not going to talk about insurance. I don't know. The juries don't know. So maybe the juror gives, $1.5 million, but all you have is $150,000. So who's going to pay the rest? And now what you're doing as an insurance company is you're failing to protect your insured, your policy holder, who's been paying you those premiums, right? Monthly or, 3-4 times a year, they're paying you the premiums, and you're not protecting the policyholder. So you're leaving the policyholder exposed. So then a lot of courts will say, well, now the insurance company, it's open. You have to pay the whole thing because you have a duty of good faith and fair dealing to your policyholder. So it's really like an interesting way of doing it. But yeah, you have to write like the right kind of letter and set it up properly. There was some books that were written on that. And I believe there's like 10 or more factors. But if you have an experienced attorney that knows how to do that, and if you're in a state that recognizes that, you could do it. Like New York, it's very hard. They've only been like a handful of cases. I guess the difference is the extent to which the conduct has to be, like in some states, just not tendering the policy when they should have and not appreciating the risk could lead to an open policy, right? Like I think Oregon has bad faith law, California, a lot of states, but New York, it's much harder. They look at it as more of a contract, and they just kind of say that it doesn't matter. They don't have to. They could have made the right decision. It's like a decision they made, more like discretion. I don't know. I'd have to look at the decisions to see how they rationalize it, but I know it's very hard to get it in New York. Okay, and then Secreting says, hey, Arkady, can you explain what Eggshell Plaintiff is and speak of any cases you know of? Yeah, so Eggshell Plaintiff basically refers to the fact that the defendant takes the injury victim or the plaintiff as they find him or her, right? So one plaintiff could be, let's say, an Olympic athlete, a bodybuilder, perfect health, and he's crossing the street, and a car comes and hits him. And he says, yeah, why did you hit me? And he just keeps walking. He's not hurt. He doesn't fall over. Now, the same thing happens, right? The car's coming and it hits a person crossing the street. But this time it's an older person, maybe like an octogenarian, right? Somebody in their 80s who's very frail and vulnerable. And when the car hits him, he just falls over and his head hits the concrete and his head splits open. Now his blood from his head, skull fracture, really bad brain injury. So, the defendant can't say, well, it's the same conduct, right? I shouldn't have to pay. I should just go. No, it doesn't matter, right? The fact that this person is 80 and very vulnerable, and he has tremendous injuries. He might have a $10 million, $20 million case. They have to pay that, right? They can't. So that's the Eggshell Plaintiff. That's basically you take the plaintiff as you find him. And in terms of cases, yeah, I mean, there's a lot of cases with that. Every case where you have any kind of pre-existing injury, meaning, everybody's going to have something, right? Any kind of vulnerability, any kind of frailty, any kind of, anything like that, right? Those are going to be pre-existing condition cases. Those are going to be Eggshell plaintiff cases. And yeah, so it's just, but it just depends on how you frame it, right? A lot of lawyers don't know how to handle that. So they get all worried and they think, oh my God, my client already had a prior injury. They're already hurt. I can't do this case because the defense is going to say it's not from this crash. You had everything before. But of course, right, if you had the injury before and it's the exact same injury, well, then you don't have a case, right? Because you can't sue for this crash because this crash did not cause anything. So the way the pattern jury instruction works is they say it's to the extent that it was made worse by this crash, right? It's what did this crash do? But the fact that you already had a prior condition, see, I think that's actually a protection under the law, because you could argue, sure, they already had a condition. So like, for example, if you take 10 as being perfect, if my client was at a 10 and he got into this crash, okay, they take him down to like a 7, he'd still be okay. But my client was at a 6 before, and now this crash took him down to a 2. He's got less to give. This is like what pushed him over the edge. And there is no more. So it's like about baselines, where your baseline is. Do you start at a 10 or do you start at a 5, right? It's about coping, your ability to cope or deal with an injury. And it's about reserves, how much you have left in the tank, right? Just like if you have a full tank of gas, you can go. If you have very little, like it says, running on empty, you just don't have much. You have less to give, right? So it's about those things. And there's ways to argue that. And then RG says, in a personal injury case, after 40% for the law firm, medical bills that could be around 25% to 30%, is it normal that the plaintiff affected person gets around 35% left? The attorneys get more money, ? Well, I mean, they're not supposed to, right? That's not the idea. The idea is contingency means that they're doing it for free, right? They're paying for experts. They're doing all the work for free, on the idea that if they win the case, they're going to get a percentage. Like in New York, we have 33%, and some places they are allowed to charge 40%. But yeah, I mean, and then medical bills, the same thing, right? In New York, the way it works is medical bills get paid by the no-fault, which is a different policy. So they just get paid. So you don't have to worry about that, right? But if you don't have that, then I understand what you're saying, that you have to pay the medical bills, and that could be like 25%. So, I mean, essentially, if that's the case, then the lawyer has to, really go to trial or prepare the case and get you a higher settlement so that everybody could get paid. Because otherwise, if it's a low settlement, it becomes a problem, right? Because they just take, everyone else takes it and you get less than others. So it's not right. I agree with you. It's just not right. And then Bear says, my attorney said he doesn't like to put time limits on his settlement package. It's his version of a demand because State Farm tends to ignore it. I haven't been deposed yet, 14 months from trial. Well, I mean, the time limit is an idea, right? That's the idea of the opportunity or the chance. If you don't put a limit, then it's like empty letter, right? Well, I mean, you could send a letter and just ask them to pay, and then they could respond, but you're not really putting any pressure on them. See, the whole idea of the time limit is to put pressure on them, to flip the script. Because what do the insurance companies want you to do, right? They want you to make a demand. And what's a demand? I'm demanding, I'm begging for money, right? And I don't like to do that. Why should I beg for money? Like, my client is hurt. I'm representing a serious injury victims. I want to come in with a position of strength. I want to say, look, this is a good case. Pay me. You have 30 days. If you don't, that's fine. But then that $1 million that's in the letter, it's going to be gone, right? Like the train that left the station. It's never coming back. You'll never have a chance for $1 million again. When I go to trial, it'll be $5 million. And then do what you want to do. Their head explodes, right? Because now you're putting pressure on them. They don't want that risk. They don't want that exposure, right? So you're kind of like, you're basically in a better position that way, I think. But some lawyers, every lawyer has their own style. A lot of people do it the old-fashioned way. They just send a demand letter. It's like a one-page demand letter. It just says, my injuries are a herniated disc, and please, I demand whatever, $100,000. And then look, what's the insurance company going to do? They're going to call you up, and they're going to say, oh, your demand is $100,000. Oh, that's too much. we have some money on it, but you got to come down. And what they're doing is they're trying to drag you down until they get you to their, their ballpark, what their range that they're happy to pay in, like whatever they have it assessed in, because they've already evaluated it and assessed it and have it written up, right? So maybe they want to pay like, from 10 to 30, they want to get you down there. And then as soon as you say 30, well, guess what? You can't ever go back up again, right? So now they're kind of like pushing you down. And also, if there's no limit in the letter, well, they can call you a year later, right? They can never call you. So, so you just have to like the letter. I think the letter is good, but you have to like do it the right way. You have to set it up, not just with the limit, but you have to tell them if the deadline passes. Like, for example, today is January 23rd, right? So I give them until February 23rd. But February 23rd at 5 p.m., if it's $1 million now, at 5:01 p.m. on February 23rd, it's going to be $3 million, right? And then just stick to that. But you got to really have a good case. You have to believe in it. You have to stick to it. You can't be bluffing, because then they'll call your bluff, and then they'll become a problem. And then Combi says, my lawyer sent a $250,000 policy demand. The insurance lowballed a $100,000 offer. We are now seeking $2 million going to facilitation. What's your opinion on open policy? Yeah, I mean, look, if you sent that's the policy limit. That's all they have is $250,000. If they didn't pay it, and the policy could be considered open as long as the letter was sent properly. All the different tenets of what's required by law were met in the letter, and as long as you're in a state that has bad faith law with open policy precedents, you should be fine. And then Playboy says, what does it mean when the defense counsel sends out a demand for non-needed surgery after depositions at a summary judgment hearing? I have an ACDF of C6, C7, but before the deposition, but they kept postponing. Pre-trial is April. So it's a notice of what? A notice of a demand for non-needed surgery? I'm not sure what that is, non-needed. So they're telling you that your surgery was not needed? That wouldn't be a demand. That's usually what their DME doctor could say, right? Because they have a DME, a defense medical examiner. They call it independent. It's not really independent. It's their medical examiner. The insurance companies are the defense lawyers, right? These are courtroom doctors. They're not real doctors. They don't usually treat patients. They just come into court and they say, well, you're not hurt, and you're not hurt, and you're not hurt. Nobody's hurt, right? So these doctors, what they're saying is that whatever surgery you had, this ACDF, the anterior cervical discectomy and fusion at C6, it was not medically necessary. That's what they're saying. So that's fine. That's their opinion. So you just have your doctor say, no, it was. You have your surgeon come in and you just push it towards trial, and you'll do well. You'll do well at trial or something like that. Good luck. And Tom says, got into an accident in New Jersey. The other vehicle sideswiped me hard on my driver's side, and he didn't stop after and caused me to chase him into an exit. Police report shows both the vehicles close to the separation white lines. Does that mean it's a 50-50 fault? No, not at all. I mean, I wouldn't really worry about the police report, right? Because remember, the police just come after the accident's over, unless the police were there and they witnessed the accident, right? Basically they come later. Whatever you tell them, they're just going to write down. It doesn't really matter. What matters is, what actually happened. So just, have your story straight as to what happened. If the other vehicle sideswiped you, that means the other vehicle changed lanes without looking and making sure it was safe and open to move into that lane, right? And so that they're at fault. So if the other vehicle's at fault, then it should be 100% not your fault. And just have like a real trial attorney who knows how to prove liability, who will hire like an accident reconstruction if you need it. We take all the steps and really knows how to win the case. But I don't think that means that it's 50-50 at all. And then Donna says, hello, do you know any pro bono lawyers in Delaware? I know some lawyers in Delaware. I don't think they do pro bono. I know some lawyers in Delaware, I believe, that do personal injury. Yeah, that I've worked with before. I could probably give you their names. And then Alora says, How much do most attorneys able to lower medical liens by? What's most likely will my portion be from 100,000? Well, no, that you have to ask your lawyer, right? Because I don't know how much your liens are, and that's more of a specific question. So you'd have to ask your lawyer. But I'll tell you that, lawyers do lower the liens. It's not like they lower the liens by a certain percentage, right? It just depends on the facts and circumstances. So, for example, if you have a big settlement, like $1 million, and you have small liens, like maybe the liens are, the physical therapist wants to put $20,000 lien. Well, you can call and say, hey, could you lower it a little bit? And they might lower it to like 18, but they're not really going to, lower it in half, because they're going to say, look, there's $1 million, there's enough money for everyone. So why should we take less? Because remember, the whole reason we put a lien on this case was because we gave you medical care for free, which made you feel better, but as importantly, maybe not more importantly, but as importantly, it also allowed you to have this case, right? Because for a personal injury case, you have to show that you have medical evidence, right? That's what the case is based on. So we gave you that through the treatment. We gave you the medical record. So now you're saying you want us to take less money, and what if your case was lost? Or what if the plaintiff just said, you know what, I don't even want this case anymore. I don't care. I'm moving to like Thailand or whatever. Well, then guess what? Like, we would just take a loss, right? We don't have any way of getting our money back. So they have a valid point, right? But if you have the opposite situation, if you have like crazy liens where people are inflating their bills and they're saying like, I want $100,000, and the whole case settled for like 25,000 is the minimal possible. Well, now you have to say, look, everybody gets a little piece of the pie, but you have to be reasonable, and the lion's share has to go to the client, obviously, right? You can't give the money away to other people, So there's different ways to do it, but there's not really like a percentage that I'm aware of, especially like across the whole country, right? Because there's so many different states and different situations. But you just basically you call them up and you just talk to them. They're just doctors, and they could reduce their liens. And RG Society says, thank you, you're the best. Oh, thank you so much. Yeah, I'm happy to help. And Playboy says non-emergency surgery is what it says per CPLR 3121. Oh, non-emergency surgery. Okay. And you're saying they gave you a notice about that, right? Not emergency surgery. Yeah, I have to look at the notice to tell you what it's about, but it's probably not a demand for non-emergency surgery. It's probably a demand for something else. I think 3121, I believe. Let me see. 3121, I believe, is just a standard trial notice. That's just that's basically it's basically a DME, a 3121. That's when they ask you to do a physical or mental examination, which is they call it the independent medical exam. So that's just a IME. That's what they're asking for. And it's actually a DME, because that's going to be the defense medical expert. So if you have a serious case with this was the one with the ACDF, right? So what I would do is have your lawyer hire like one of these watchdogs to go with you to the DME and watch everything and write down what they're doing, right? Because sometimes they do the exam really quickly, like in 5 minutes, but then they write in the report they spent an hour. So you want to make sure they're being honest, and having an independent observer is a good way to do it. And Jose says, can ablations get you to 6 figures? Yeah, possibly. Sure. Ablations are pretty serious. They're burning the nerve. It's possible if, you could show the overall impact on your life from the injury, from the crash, or from the, whatever the incident was. Yeah, it's possible. And then Donna says, these lawyers down here want $300 for a half, or want $300 for half an hour. Why? What's up with that? Well, I don't know. It's hard to say. It depends on the type of case and the type of work that's involved. So, and Rob says, the doctor that performed my surgeries on my knees said that in his medical opinion, the accident caused the injuries. How important is that going to trial? No, that's critical, right? Because that's one of the things you have to prove. That's known as causation, right? Did the crash cause the injury? Because if it didn't cause the injury, then you lose the case, because you have to show, number one, that the defendant was negligent, and negligence is the failure to use reasonable care. But then the second question is, if they were negligent, was the negligence a substantial factor in bringing about or causing the injury? And if it wasn't, right, somebody could be negligent. They could hit you in the rear, but it was like a little fender bender. You could barely feel it. It was like a paint, not even a paint chip. Your car looks beautiful. You're not, couldn't be hurt. No one was hurt. Nobody went anywhere. And then they say, great, they were negligent. They shouldn't have hit you in the rear, a little fender bender, but didn't cause anything. So now, thank you for playing. Go home. You get no money. So yeah, that's critical. That's important that he said that. That's good. And Truth says, have a question about MMI. What doctor has the authority to fill that form out? Is it your primary care doctor? Yeah, I mean, usually like MMI could be your primary care doctor. It could be your physical therapist, whoever's treating you for the accident, whoever's like the main doctor kind of quarterbacking all your care. Because yeah, that's the maximum medical improvement, right? So if you've reached maximum medical improvement, well, now you do not need any more treatment. So then that's what maximum medical improvement is. They're gonna stop you from treatment. So that could be one of your main doctors should do that. And Tom says, the accident caused me neck and back injuries with 2 discectomies and injections and 10 months of therapy. Thank you. Oh, no, I'm sorry to hear that. Yeah, that's a serious case if you had a discectomy, injections, and therapy. Absolutely, that's a serious case. That could have substantial value. So, yeah. Yeah, if you need me to just text me about that, 347-566-9595. I'm happy to chat. Well, that's the one with the lane change, right? Yeah. Yeah, but I wouldn't worry too much about the police report. That could be a big case. RDOT says, hit the like button. Yeah, absolutely. Please like and subscribe to our channel. Let us know what questions you want to have answered. Also, if you have video topics that you want to see in the future, let me know and I'll make some videos. I'm looking for some new material, new video ideas. So I'm going to do some more verdicts, some more, different maybe lawsuit process. I know everyone wants to know how much you're going to get. So of course, we'll try to factor that in. But yeah, let me know if you guys have any ideas. And Playboy says they already conceded that they were aware of the issue, but they tried to say it's my fault. No, I'm sorry to hear that. Yeah, a lot of the times they do that. Unfortunately, the defendants are not always fair. They're not always reasonable. And Mike says, if there is $1 million policy limit, is the at-fault insurance still cheap with offers? I mean, it depends, right? Usually not, right? If they have $1 million policy, they're going to be more likely to pay you money. But you got to remember, just the fact that they have the $1 million policy doesn't mean that they're just going to start paying you money. So I guess what I mean by that is what they're ultimately going to look at is liability. Who was at fault? Were they at fault? And their exposure. Like, do you have a trial lawyer? Do you have somebody who has a record of getting $1 million results? Are you aggressively litigating the case? Have they filed a lawsuit? Sometimes people don't even file a lawsuit and they hold a case and they're like right up against the statute of limitations, and like tomorrow or in a few weeks, the case is going to be dismissed, right? Because you have to file within 3 years, or some states it's 2 years, or some cases like against the city, it's only like a year or a year and 90 days. So you have to be mindful of that too. And also, the injuries, like if you have a serious injury, sure, they're going to be, fair with the offer. But if you have like a mild injury or no injury, then they're going to say, well, who cares, right? But what I have seen with $1 million policies is that, like, say, for example, you have 2 cases, right? One case is like let's say it's a soft tissue little crash, right? Somebody gets like 2-3 months of treatment and they have like a bulging disc, but then no injections, no surgery, no nothing. But let's say one case, it's with like a $25,000 policy. So they might offer you like nothing and say like, look, we're going to try to dismiss your case for lack of serious injury, or they might offer you like $5,000 or $7,000. But if you have the same case, but you're up against a $1 million policy, they might give you a little bit of a sweeter offer, like $25,000, $30,000, right? just to make you go away, because they don't want you to then file a lawsuit against them and then possibly get like an injunction or surgery and then try to hit them for like 500. So I guess it's like, that's what I'm seeing usually for soft tissue injuries. And then Pokey Trainer says, how long does a demand letter that's been sent out for the amount take for settlement, opinion-wise, or based on your experience? I know that you can't provide an exact date, but opinion-wise, for a ACDT or commercial vehicle. So you're saying, how long does the demand letter that's been already sent out for an amount take? Well, I mean, I don't know. See, I don't know how the demand letter is written. That's what we talked about before on this live, remember, just a few minutes ago. So if it's written the way I write them, it would be 30 days or less, right? Because what I do, I give them a deadline. So I say, look, pay me $1 million. You have a deadline like February 23rd, 2025 at 5 p.m. If you give me, the money at 5:01, forget it. I'm not taking it. And you have to stick to your guns. I'm going to trial, and it's going to be not 1 million anymore. It's going to be like 3 million, right? So that gets them to like be interested and maybe like start making you offers, because you're putting them in a corner. But if you just say like a generic demand letter, like, oh, here's my demand, I want like $1 million, they're like, okay, who cares? They just throw it away. You could be waiting for like a year, you could be waiting for 2 years, you could be waiting forever, So, there's not really, but yeah, usually, I mean, if it's ripe, meaning if the case is ripe for settlement, what I mean by ripe is you have all your depositions done, they know what your injury is, they understand liability, right? All the factors that would be explored at a trial have been addressed, and then, yeah, you come in and you say, look, I want to settle it. Usually from when I send the settlement letter, it settles either in the 30 days, or if it doesn't settle in the first 30 days, sometimes it settles, 4 months, 5 months later. But yeah, that's usually what it is. And Donna says, when is a good time to talk to you and hear your voice? I keep getting that I have to text. Oh yeah, no, just text me and then we could schedule a time to chat. That's usually how I do it. So you just text me, and when you text me, I just ask that you give me a little bit of information, like your name, brief facts of what happened, just so I could picture it, what happened in my mind, just like, what sentence or two, your injuries, your city, your date of incident, and then I just schedule a bunch of consults. So I'm always like scheduling consults, and then I just do the consult calls. So it's pretty straightforward. And then Higher Credit says, what is a motion to compel, and what is a summary judgment against one of 3 defendants? So a motion to compel is just like when you want something to be the judge to force something. So like compel, like for example, you asked for documents and the defendant didn't give you the documents. So you file a motion to compel production of the documents, basically have the court force them to do something you want them to do. And a summary judgment just means that you have judgment as a matter of law, that there's no question for a jury to decide at trial, that everything's already been decided. For example, in a rear end, right? You're standing at a red light, somebody rear ends you. There's no reason to have a trial about who's at fault. You're stopped, you've been stopped, the light has been red, it's been like, 30 seconds or whatever. And now all of a sudden this guy's coming and he rear ends you. It's his fault. You just have affidavits, a police report, dash cam video, whatever proof you have, photos of the vehicles. And then you're going to get a judgment as a matter of law. And if it's one of 3 defendants, that means one of them, moved for summary judgment. Or it depends. Who are they filing a motion for summary judgment? That means they're asking for summary judgment, or maybe you are moving for summary judgment against one of them. So one of them perhaps should be out on summary judgment, and the other ones, there are questions of fact that a jury should decide. So that's usually how it works. And Kevin says, my lawyer sent out a second RFA to the defendant, police officer, after we found out about distracted driving. How important is a request for admission? Yeah, I mean, that's important. That's one of the discovery techniques. So a request for admission is basically you're asking them to admit certain facts or certain information. We don't have really requests for admission in New York. We have a notice to admit, but it's similar. So basically, if you found out that the officer that was involved in the crash with you was a distracted driver, for example, he was on his cell phone, so you could then serve a request for admission, like that you had a cell phone in the car, that you were using the cell phone, that you were, admit that you were like either on a call or looking at a TikTok or whatever he was doing, And then if he says no, then you can take a deposition and explore further or ask for further evidence, like subpoena the cell phone records. Yeah, so it's important. It's a discovery technique. And then Tom says that I had an accident in Queens while I'm a passenger in a vehicle not too long after my discectomy was done. It caused an inflammation on my lower back and a shoulder arthroscopy procedure and a minor head concussion. Oh, that's pretty serious. Yeah, no, I'm sorry to hear that. That's pretty serious. Absolutely. Yeah, feel free to give me a call, send me a text, and I'm happy to chat with you and answer your questions in a private consult. Well, he also says, with more therapy and taking a pill for stress and causing ringing in my ear time to time and doing connective therapy, ADHD, or it sounds like it could be like a concussion or a head injury. That could be like a ringing in the ears. That sounds like it could be, and especially what you've written, it sounds like it could be a potential like a cognitive injury or head injury or traumatic brain injury. So for that, what I would recommend is maybe like seeing a neurologist. Now, actually, I know a good one in Queens that we work with, actually, if it happened in Queens. But yeah, just send me a text, 347-566. Okay, I'll drop it in the chat too. And then it's 9595. And then you could just text me and I'm happy to do a call and help out. And JRM says, last week I signed an ISO form. What are the next steps and when will depositions begin in Queens, New York? Okay, yeah, so an ISO is like basically that's your lawyer. Usually it's your lawyer asking you to sign a form, and then they send the form to this ISO company and they do a search on you to see if you had any other claims, like any other car crashes, any other medical treatment, and it comes back like an ISO search. So they're just trying to like verify that you don't have, if you said you do not have any other prior accidents or subsequent accidents, they want to verify that. So that's just something that's done in some cases. Depositions, I mean, it doesn't really have any correlation with depositions. You don't have to do an ISO search at all. I mean, sometimes people do it, but there's no like, you know what I mean? One thing has nothing to do with the other. Like you don't even have to do an ISO. So it's not like I can't tell you that you signed an ISO that you're going to have a deposition in a week. The two things are just like, it's like apples and oranges. They have nothing to do with each other. So, but the deposition, it should happen. Like if your lawyer filed a lawsuit, if they appeared in the lawsuit, the defendants, if there's been a preliminary conference, the first meeting with the judge, that's usually when depositions are scheduled. But if you had the meeting with the judge, the preliminary conference, then at the preliminary conference, they're going to schedule it. But like if you had a preliminary conference, let's say in January, right? The depositions might not be until like May or June because they have to exchange documents and, get ready. And then people's calendars get booked up because they have other depositions and trials and this and that. So they have to find an opening that everybody has time for. So that's usually how it works. And then Felipe says, does treating for 3 years straight make the case bigger, meaning getting more money? I mean, yeah, depending on the type of treatment. If it's a proper treatment, then yeah, it could be. It could be, absolutely. And he also says, can you look up some sideswipe accident verdicts in New York? Yeah, I mean, the verdict won't be based on, how the incident happened, whether it's a sideswipe or a rear end. The verdict will be based on the injury. So if you tell me like what the injuries are, you just text me. I could look up some verdicts for you. Or I could look up your lawyer if you're curious what results they've won. I could do that as well. And Suga says, hello, sir. Hello, chat. Hi, how are you? Great to see you. And Tom says, what's your take on this 2 cases will amount to? Well, it's better if we chat. I couldn't really I couldn't really say. I'd have to like speak with you and do a little bit of a deeper dive, and then I could give you some, input. I'm happy to give input. It's just I don't want to. It's just like a wild guess, right? Because I don't know anything about. I think you said there was a New Jersey case, and you told me a little bit about that. That sounds like it could be a serious case. There was a surgery, but we'd have to know how much the policy limits are, right? If there's a big policy like $1 million, it could be even $1 million because you had a back surgery. Now, the Queen's case, I don't think you wrote too much about it, right? Other than you had one. So I'd have to like speak with you. It's better to speak. Oh, that was the one with the possible head injury, right? So yeah, I'm happy to speak with you, and that I could give you a better answer. And then Sugar says, my court judgment forms have been sent to the judicial officer. How long could it take to receive an answer? And will the officer approve it as long as the firm is done correctly? Yeah, if you already have a judgment, then it shouldn't be too long, because that's the last step, right? Getting a judgment, that's the last step. Then you already have a judgment, you just have to enforce it and get it paid. So it shouldn't take too long. And James says, hi, how are you doing today? Oh, very good. How are you? And Rick says, is it ridiculous for me to request an x-ray of the anchors in my shoulder? I'll pay for it. I don't know. I mean, like, you'd have to ask your doctor if it's necessary. Why would you want to request one? Like, just for the anchors? I'm not sure. I mean, if the doctor said he put in anchors, then they're in there. See, usually the X-ray is more like to look at the injury and try to like treat the injury. But you're saying you want to do it just to confirm that he put the anchors in, like you don't believe him or something. Like, I mean, I don't know. It depends on. I don't think it would really help your case. As long as it's in the operative report that the anchors were put in, then they were put in, and usually everyone just goes by the operative report. So I don't think you really need it for the case. But if you want to, I guess you could. Fantastic says, long time and trying to make my attorney settle my case. I won my Social Security disability permanent in 2010. The state was found negligent and guilty for not providing care for me. Oh, I'm sorry to hear that. Yeah, but that's good that you won the disability case. And Sugar Bay says, thank you. Yes, the default was signed, just waiting on the court judgment to be signed. Thank you. Yeah, I think that should be signed pretty quickly. It usually does not take too long. And Tom says, worst of all, I am from taxes, and from the first case, I have been stuck in New Year without my wife and kids for almost a year, and with a mortgage to keep up and drain my savings with no workers' comp. Oh, I'm so sorry. Yeah, no, that's serious, especially if you have like a head injury, you're not able to work. And yeah, no, I'm sorry to hear that. But yeah, just text me. I'm happy to help. I'll try to do my best to help. And I think that, maybe I could help. We've been helping some people. Like sometimes we speak to someone, we give them some advice, or we give them a lawyer, and then they use the lawyer, and then, hey, the result is like multiple millions. So it's great. I love to see justice be done and people get good results. That's what it's all about. Yeah, so let me see. Any other questions? Or if not, I guess we could end early. It's not too early. We've already been on for almost an hour, so I guess that's good. Yeah. Oh, Boubacar Salim says, after discovery, what is next? Yeah, so after discovery, remember, discovery is when you're trying to get information, either documents or depositions where you question witnesses. Now, you can question the defendant can question you. You could also question non-party witnesses. You could also get documents from non-parties like FOIL, or just serve subpoenas on non-parties. And then once all that is done, usually you certify the case as trial ready, and it goes on a trial calendar, which is kind of like being in line at the store. So you're in line, let's say you want to buy milk and bread, right? But there's people ahead of you, there's 10 people. So you just have to wait. But while you wait, they could try to settle your case. They could try to do pre-trial conferences. You still have to get your medical treatment, and your lawyer should still be at that point trying to settle the case and moving along. And then once your turn comes, at the register, that's like the trial, right? When you've been waiting and then finally get up there. And Paul says, good evening, Arkady. When is underinsured helpful in a personal injury case? How does this work? Oh, underinsured. So yeah, basically underinsured is like UM. So the way it usually works is if the defendant, doesn't have enough insurance, if they're underinsured, like for example, they should have, let's say, a big policy, or let's say you get seriously hurt, you need a surgery. So you're hoping they have, like $1 million policy, but they don't. They only have 25,000. But you have a big policy. You have $1 million. So what happens then is you take the 25 from them, and then you go under insurance or against your own, and you can get more money from your own insurance because you were a careful driver, insurance person, whatever. You have a lot of coverage, and they didn't. But you have to have more than them. If you have 25 and they have 25, you can't go against your own. So that's usually how that works. So yeah, it happens. I mean, it happens. Sometimes you have to arbitrate, do uninsured arbitrations, arbitrations. So, yeah. And Sugar Bay says, I had the other defendants in the case dismissed and the other in default. What happens to the CMC date in the calendar? Do I still need to go to the CMC in October? Oh, I see. So like one defendant was out of the case and the other one is in default. So I guess you probably don't, right? Because that's a case management conference. So that's like a compliance conference. We don't call it CMC in New York. We call it compliance. But it's the same thing, case management. They're managing the case. So yeah, if you don't have anyone in the case, one guy's in default, the other one's out, there's no reason to go. But I'm going to call the court just to be sure. You don't want to just like not show up, because then the court could dismiss the case. Like I had that happen on this case. It wasn't me. I wasn't involved in the case. Actually, I was involved earlier. I represented this client, but I'm not representing him now. And so he settles the case, but only against one defendant. Okay. And then his lawyer doesn't show up to the CMC once, but then the lawyer doesn't show up twice. And then the judge just dismisses the case. So it's kind of dangerous. And it's actually in a county where it's going to be very hard to restore the case. You might not be able to restore it. So I don't know why they did that, unless that settlement with the one defendant was like meant to be a global settlement. But I don't think so, because they wrote a letter and they specifically said this is just a settlement with one defendant. The case will continue against the other defendant. So they wrote that letter to the judge, but then they didn't show up. So you see, it's very dangerous. So it's better to call the court. Let me go back up. Now we got a lot of questions. I got to scroll back up to see them all. Oh, Fantastic says, for me, the state never followed through with the rest of the surgeries required. All they've done is deny. And I think I may need to reopen my Social Security disability. Yeah, I mean, sometimes you do need to do that if they're not being fair, they're not paying. Because the workers' comp attorney is not doing anything, and I've paid for my own medical care for myself. If I send a text message to you, so maybe I can speak to someone, I believe this case is ready to settle since the state has denied everything. Yeah, I mean, depending on where you are, I can maybe recommend someone for you. I don't do just straight workers' comp or Social Security. I only do like the third-party personal injury, but maybe I could find someone else that does for you, depending on your city and where you are. And then Bubakar says, thanks very much, or you're very welcome. And James says, my lawyer got all my medical records and invoices. What is he trying to do? Well, no, not really trying. It's just that's what you need to get all the medical records, of course, because if you don't have the medical records, you're going to have a hard time proving the injury. One of the ways you prove the injury is you get all the medical records and the invoices too, because those are your bills. So one of the things you can claim are medical expenses. So you want to know medical costs and the future costs of treatment. That's just doing their job. It's normal. Tom says, because I'm thinking of taking a family loan, and how long do you think these cases will take to get to settle? Yeah, I mean, like it depends what stage they're in now, right? So if the lawsuit has just been filed, it might take a little longer, but if you're already past depositions, then of course it'll be much shorter. And of course, a case could settle at any point. So it just depends on how you prepare everything and how you build it up for settlement. And Sugar Bay says, yes, exactly. Okay, thanks. Good to know. Makes sense. And Fantastic says, I forgot to mention when I went under workers' comp care, my I forgot to mention, when I went under workers' comp care, my employer, the state of California, fired me. Oh, I'm sorry to hear that. Yeah, that's not good. And Mike says, so Mike again, a female had ran the light and left the car on the scene. It was a rental. She ran away. I need injections. They have $1 million policy. I am 3 months in therapy. Nothing is broken, just pain. Is that lucrative? So somebody ran a red light, right, and left the car. And you need injections with $1 million policy. So it could be a good case. Yeah, $1 million policy. If it's just injections, it could still be like 5 figures or even into the 6 figures. It could even be like, I had an injection case that got over 100,000. So you had 3 months in therapy. Just like listen to the doctors, see what they want to do. There might be pain management. You might need a type of other injection, like epidural injections, percutaneous discectomy. That could make the case even 300,000, 500,000. It's possible. And Hassan says, how much compensation under workers' comp law can you get if you're injured at work with a broken wrist? Yeah, so I mean, like, it'll depend on the case. Like workers' comp, the way it works is you're just getting your medical bills paid, and you're also getting your lost wages paid, right? So your medical bills is not money that's going to you, it's money that's going to the doctors that are giving you medical care. Now, the lost wages is going to you because those are your paycheck losses that you would have earned. And then you also get some money for yourself. But usually, like, depending on the severity, if it's a broken wrist, if it heals, if there's any type of disability, you could try to get what's known as a Section 32, where they give you a lump sum payment. But how much, I couldn't really tell you. It's always different. It's up to the workers' comp board. Depends on your salary, right? Depends on how much medical care and what your medical bills will be. So it's best to ask your workers' comp attorney. And James says, is he trying to solve my case by getting my medical records and invoices? It's been over a year. He has received my medical records 2 times. Well, it's hard to say, but like if he's just keeps getting medical records and he's not going to court, that's not a good sign. It might mean he's trying to just settle the case for whatever he can get. Like you usually want to file a lawsuit. That's the big thing, right? And then you also get medical records, but that's more of a secretarial job. You just get them. And of course, you don't want to go to court without the medical record. But like at the same time, you don't want to just be getting medical records and just sitting there looking at medical records. You want to be going to court and pushing the case and prosecuting the case through the court system. That's key. Tom says, last question. How much do you think those 2 cases will settle for? Oh, yeah, I think I answered that. I said it's best for us to talk because I don't know the full injuries. I don't know the full. See, in order for me to give you value, I really have to understand the liability, like what happened, the city, what stage it's at, what your injuries are. Then I could maybe, and also what the policies are, right? Because I don't want to tell you, $1 million, but then the policy is 25,000, then I'm a liar, right? So yeah, it's better to just do a consultation for something like that. So Dasani says, good evening, Mr. Arkady. Why my personal injury is in the Supreme Court, New York City, and how long it takes to have a hearing. So the Supreme Court in New York, do you mean Manhattan, New York City, Manhattan? How long it takes to have a hearing? What kind of hearing? Is it the deposition? If you're talking about a deposition, it might take a few months, from when you filed the lawsuit. But why is it there? Usually the case is filed where you live or where the crash happened or somebody lives. So if somebody either lives there or it happened there, that's where it's going to go. Yeah, that's known as venue. Venue is like where a case can go. Okay, everyone. I guess that's good. Like we did a few questions and answers, and spent about an hour, so that's good. I have to run, but thank you so much for being here. And like I said, please like and subscribe to our channel. If you want any videos, let us know. What video topics you want us to do, and we're happy to do it. If you need a consultation, just text me. I'll drop my number in the chat one more time. And all the best to you. Our goal is helping serious injury victims and families. All the best. Have a great night and talk to you very soon.